Someone sent me this video. It's another news now. Go ahead and subscribe. A couple things I want to address in this video. The first thing I want to address is filming in a courthouse. Arizona rules of the Supreme Court. Use of portable electronic devices in a courthouse. Photography, audio recording, and video recording in a courthouse are permitted, but the following restrictions apply. Outside a courtroom. In areas of a courthouse other than courtrooms, no one may photograph or record an individual without that individual's express consent. So express consent means they have to state before you start recording them, like sign a waiver or state verbally that they are okay with you recording them. They have to actually express consent prior to you filming them. So that's regarding people. Local orders. By local administrative order, a court may adopt further reasonable limits on photography or audio video recording in a courthouse that are not inconsistent with this rule or Rule 122. Rule 122 is filming inside a courtroom. So we've dealt with people. We know that they can make further reasonable limits, but this F is the big one. It's use of a portable electronic device outside of courtroom limitations. Except as provided in paragraph C, D, and E of this rule, a person may use a portable electronic device in a courthouse subject to the authority of judges, clerks of the court, or court administrators to limit or terminate the activity that is disruptive to court operations or that compromises courthouse security. So this is another limit on your ability to film. If you go in there and act like a jackass, then they are going to stop you from filming. The next thing is right about this mark right here. Mr. Ginger Rogers says that the Katz v. United States decision somehow allows him to film in public. Again, misunderstanding what the filming in public things are about, but that's fine. Katz does not deal with that though. Katz is a 1967 decision. It dealt with the Fourth Amendment. The government eavesdropping activities violated the privacy upon which petitioner justifiably relied upon when using the telephone booth. The Fourth Amendment governs not only the seizure of tangible assets, but extends as well to the recording of oral statements. Because the Fourth Amendment protects people rather than places, its reach cannot turn on the presence or absence of a physical intrusion into any given enclosure. Although the surveillance in this case may have been so narrowly circumscribed that it could constitutionally have been authorized in advance, it was not in fact conducted pursuant to the warrant procedure. This is a Fourth Amendment case, and it also doesn't say that there is no expectation of privacy in public. What it does say, though, is right in here, what a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Now, again, this case is talking about the Fourth Amendment, so I don't think that this really assists anybody in a First Amendment case, but this just says constitutionally protected, and if you're going to try to make out that this case says there's no expectation of privacy in public, you're going to have to contend with, but what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. You're going to have to deal with that. So, good luck. The case doesn't say what you think it says. It doesn't hold what you want it to hold. You're stretching, and you are miseducating people. Speaking of miseducating people, Furry Potato is now of the belief that USC 2000, 42 USC 2000 AA is going to get her camera equipment back. Some obvious things. This was not written by a lawyer. You could instantly tell it's not written by a lawyer. First of all, if it was written by a lawyer, it would be a demand letter, not a petition. It would have a lawyer's or a law office's or a law firm's letterhead up here. And it basically, the basic format of a demand letter, as far as I've seen, it's not formulaic per se, but everybody seems to follow the same general formula. First thing you do is you say the facts. What happened? The second thing in the demand letter you say is a very quick sketch about the state of the law on those facts. Like, so you say, like, you took my camera, you know, on this date, this time, this place, you took my camera. And then when you're in the next kind of section, you're saying, okay, it's theft to take my camera, you know, and I can press charges under this, whatever. Or I can file suit under this kind of thing or this theory or whatever. Basically saying that I have a legal right to my things back, and I have a legal way of enforcing that. So that's typically like section 2, and then section 3 is where you actually like give your terms. Like, you know, if you haven't returned my equipment to me by X date at X location at X time, etc., then my your lawyer would be writing this. Your lawyer would say that, you know, I will be filing suit on behalf of my client in the Superior Court of the state of California, in the county of whatever the hell county this is in, and, you know, etc. So that's kind of the way demand letters work. So I am firmly of the opinion that Zoe herself wrote this. A lawyer probably would not also include, I've never seen a lawyer include a copy of Cornell Law University's printout of a statute. So yeah, that's just a little weird. Normally you mail it off too. You wouldn't necessarily hand deliver it. I've never seen it hand delivered. I'm not saying you can't. That's a little weird though. So lots of indications that this is not her lawyer presenting it. I couldn't see a lawyer necessarily getting too far behind this. I mean, I've seen lawyers send demand letters on things that they knew they couldn't win in court anyway. Sometimes it doesn't hurt. And if you tell your client in advance that there's really no standing, but maybe you send the demand letter anyway just to see. I mean, sometimes you can't catch a fish if you don't throw your hook in the water. So what are you going to do? But yes, 42 USC section 2000 AA, it does allow, if there's probable cause, for them to take the materials for evidence. Anyway, thank you very much for watching. Please stop spreading misinformation and have a great day.